There are three, I think, reasons why responsibilities for GPs in consortia are going to be different from GPs in their own practices. The first is that consortia will be a public body and GP practices are not, they're private sector bodies, and this will mean that they're subject to law that they're not subject to at the moment. Good example is judicial review, so courts can actually review the decisions that they've made to make sure that they're within their powers. The second area where there's going to be a difference is they're going to be spending public money, and they'll come under the scrutiny of the public, they'll come under the scrutiny of Parliament, but also there are rules around how they spend that money, particularly under procurement law. And then the third area, which is a practical consideration but is really quite different, is the sheer scale of consortia. GP practices tend to be small, maybe a staff of 15, 20, 30. Patient list size is about an average of 6,000 patients. And so if you think about that with consortia, gain size is going to vary, but sort of a smallish PCT now has a population size of 250,000. That's 4,000% larger than the GP practice patient list. They're going to be employing so many more people, hundreds times more, and that goes to the core of how you run an organisation, to your governance within consortia.
Well, understanding these changes is one thing, and then introducing them and putting them into practice is another thing. What's the time scale of making some of these changes in an organisation?
I think it's very important for GPs to really be looking at that now. I mean, they already deal with the law on a daily basis in terms of running practices, managing their contracts, dealing with patient data, so they really are aware of legal issues. It's thinking about them in a different way, understanding them in a different way. There's fantastic best practice within PCTs now because PCTs are used to these kind of obligations. And I think while organisations are growing and developing, it's a fantastic opportunity to really get their houses in order, to really put in place robust governance arrangements, building on best practice and really making sure that they're fit for purpose when they come to authorisation.
Now, those are three big responsibilities that you've already outlined. Assuming you've been working with GPs, setting up the commissioning, the consortia at the moment, what are their concerns that they voice to you?
I think some of the issues, I think it's the vastness of it, because sometimes it can feel quite overwhelming to look at all the different aspects of law, and certainly areas about understanding contracts with providers, demand management, how they operate. It's going to be key, understanding how that interacts with procurement, competition. So much is being said in the bill at the moment within Parliament in the Select Committee. How's that going to impact on their obligations? If they want to provide services, how they make sure there's a really robust separation between their role in commissioning services, their role in providing services. So I think GPs feel at the moment really keen to move on with the agenda, but also realising the enormity of what's ahead.
Gill Thomas, thank you very much.
Thank you.